Good morning, everyone. It is noon here on the East Coast, 9 a.m. out there on the West Coast, for those of you on the wrong coast. This is the California seminar. We welcome those of you back that were at the Federal and welcome those of you that are coming in just for California. As you can see, we have our merry men from California with us. Chuck and Josh and Matt are all here today. If you were on the Federal call, you know that Chris is driving back from our cabin. I believe he's going through a dead spot right now. So just to reiterate what he was talking about this morning, and then we'll let Chuck take over and add on to it. The main thing that my brother was getting across this morning is the zero tolerance policy that Biden has put out. They're going to be tougher on their inspections and with their administrative actions. And that was Chris's main point, was he wants everyone to please, if you don't already have a pocket FFL or a buffer FFL or whatever you want to call it, an FFL in the background, to please think about that now and have yourself a second license that we can move right over to in order to avoid any type of discontinuance in your business should anything go awry. The other point Chris wanted to put out was, if ATF's going to start making examples of people, let's not let an FFLGuard client be the first example. We're asking you, please, 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 more than ever, to stay on top of your inventory, your paperwork. Remember the most important, the deepest violations that could get you in the most amount of trouble as far as an administrative action would be missing guns, missing 4473s, failure to report multiple sales, which California, you guys can't do that, can you? And also the NICS or DROS checks out in California. Make sure you're recording all of that properly. So with that being said, I'm going to turn it over to Chuck and his merry men, and let us know what's going on, Chuck.
So I'm going to take a minute and talk about the Second Amendment lawsuits that are working their way through the courts, make sure everybody understands what's going on with those. And then I want to give you a little bit of a info on CRPA. I think you guys all know I wear I wear a lot of different hats, but I am the president of CRPA, and they're doing some things with FFLs that I think you should be aware of. Then I'm going to throw it over to Matt to talk about Biden and his zero tolerance press conference that he had, and whatever we may know about Chipman. I think probably some of you guys know, I think on our last call, the rumors in DC are that they don't have the votes to confirm him, but I don't know for sure. But there's sort of a 1-2 punch potentially coming out of ATF that everybody needs to be careful about. I'll let Matt talk a little more about that regulatory issue. So on the lawsuits, we got a very, very highly publicized, a lot of attention for Judge Benitez's hat trick. And by that, I mean his third pro Second Amendment ruling. The first was Duncan, which was a CRPA case with Virginia Duncan, who has challenged the magazine capacity limitation law. And we won with Benitez, had that glorious week of freedom where probably 1 million magazines, were over 10 round magazines, were imported into the state of California and sold here. So everybody kind of restocked. Obviously, there was a lot of pent up demand. That went up to the Ninth Circuit, and we won again in front of the 3-judge panel, thanks to some of Trump's appointees. And then it was heard en banc, now just a week or so ago. Now, while it was awaiting en banc review, we have had argument in the CRPA's Roop case, which is the Black Rifle Challenge, has all the arguments, all the evidence, everything that the Miller case that was just that Judge Benitez just ruled on, that Black Rifle case. It's already fully argued in front of a 3-judge panel. It looked promising because we had 2 Trump appointees on that 3-judge panel. and we were awaiting a decision. Then Duncan was taken en banc, and the CRPA's Roop case was stayed pending the Duncan ruling in the Duncan magazine capacity lawsuit en banc hearing. Likewise, CRPA filed the Rody case, and this was the second positive ruling from Benitez, because I took a trick that I've learned from the gun ban lobby years ago when they were suing retailers, wholesalers, and manufacturers. Every municipality in a carefully coordinated effort was trying to put the gun industry out of business by making them incur so many legal fees that they just couldn't make a profit. The gun ban lobby was relating cases to Judge Weinstein in upstate or in New York, so that because he was ruling that retailers and manufacturers could have liability for the criminal misuse of their products. By the way, I don't know if you guys are all following me on Facebook, but you probably want to, because I post these updates. Some of the stuff is a bit more obscure than you might get from like AmmoLand or Bearing Arms. It's a little bit more inside baseball kind of stuff. And if you have questions about that, you're obviously welcome to ask. But anyway, so we had Roop, Rody. We also have Flanagan, which is a CCW challenge against the County of Los Angeles that it's working its way through. It's in the Ninth Circuit, hasn't been argued yet. But they're all stayed behind Duncan. The reason that Duncan, even though it's a magazine ban case, not a ammunition background check case, which is the Rody case, or a magazine capacity, a black rifle case or a CCW case, they're all queued up behind behind Duncan, because the standard of review that is adopted, and I've said this to you guys before, the standard of review that's adopted is conceivably going to be a game changer all across the board, because the courts have been applying the wrong standard ever since Heller and McDonald came down, because they wanted to rig the game so that almost nothing would be struck down. So with the en banc panel, they could change the standard of review in the Ninth Circuit, conceivably. What they should do, and I'm not quite sure why they're not, is stay the Duncan case until the Corlett case, the New York State Rifle and Pistol Association case that is in the Supreme Court right now, is ruled on. That will be briefed during the summer, argued in the fall, decided next June. So a year from now, basically, we should have a ruling from the Supreme Court that sets the record straight on what the appropriate standard of review is in evaluating the constitutionality of a gun control law under a Second Amendment challenge. But Miller, Judge Benitez's hat trick, the third case that he decided and actually respected the Second Amendment, is now stayed behind Roop. So Miller is going nowhere until Roop goes somewhere, and Roop is going nowhere until Duncan goes somewhere, and Duncan may go nowhere until New York State Rifle and Pistol goes somewhere. So that's the logjam in the Ninth Circuit, and I talked about it on Gun Guy TV. Again, follow me on Facebook, and you'll get some more of this stuff to the extent. I know you're all interested, but it's not day-to-day business. You're trying to figure out how to fill orders and get ammo and stuff. I know you have, there's life gets in the way of these broad concepts, but these cases could be game changers for all of us, especially for us behind enemy lines in California. And we're going to start offering fleur-de-lis rings so that we're all in the special Occupied France Club. If you remember Casablanca, they have these signature rings. They were to show that they were all part of the resistance. Well, that's what we are in California. We're part of the resistance, and we keep on pushing those lawsuits in order to break up the tyranny that is, Gavin Newsom and the rigged Sacramento legislature's approach. In the meantime, segueing to CRPA, Roy Griffith and Sam Paredes from CRPA and GOC are really the only full-time advocates in Sacramento now in that rigged legislature. And they've stopped a few bills this year. The big one that we're looking at is, I want to make sure I got the number not right, is 1231. I think it's the ammo and gun tax, 10% tax or 11% tax on gun or ammo sales, which we will immediately file a lawsuit against if it passes. And we'll probably be coming to you guys for plaintiffs. In fact, if you're willing to be a plaintiff in that case, you might send us an email at potentialplaintiffs@michelelawyers.com or send it in through FFLGuard, because we want to get that lawsuit ready to go so that if it passes, I'm sure Newsom will sign it. We want to challenge it immediately. But for so far, Sam and Roy have managed, along with, not to take credit where it's not due. There's circumstances going on there. It's a tax bill. It has to have 2/3 vote to pass, and they don't have the votes from some of the blue dog Democrats, Central Valley Democrats, who don't want to pass that bill. And I'm not sure if Newsom even supports it, because he knows it's going to draw litigation, and he's in the middle of a recall election, and politics makes all kinds of people do all kinds of weird things. So anyway, for now, that tax bill is stalled, but it probably is going to come up again on Thursday in Sacramento. We'll see what happens. Meantime, CRPA, you should all be aware, has a business affiliate program and is opening chapters all up and down the state. We don't know what the NRA members councils are doing. We do know that historically, some of the people that were the NRA staffers that were involved in the NRA members councils weren't doing much and weren't telling anyone, including the CRPA, what they were doing, and weren't promoting the CRPA. And for years and years and years, CRPA tried to make things work with the members councils and NRA headquarters. And there's, as everybody, I don't need to tell everybody, NRA has its own internal politics screwing up the sausage factory. But so anyway, CRPA now has chapters blowing up all over the state, and they're working with their local FFLs to mobilize and take more of a presence locally to begin with. So there's a symbiotic relationship there. So I hope wherever you are, you'll consider, maybe even sponsoring a chapter, depending on how busy you are, a CRPA chapter, so that we can, the Democrats, the Republicans are like sleeping at the switch. The Democrats learned years ago to build a farm team, start with dog catcher, then school board member, then city council somebody, and they make gun control and the Second Amendment this conflict issue because they know that generates name recognition. And having just 2 years ago gone through my wife running for judge, I realized some of these obscure races, no one has any idea who they're voting for. They're all voting because they like the name versus the other name. That's how arbitrary some of our elections are, unfortunately. So anybody who can develop name recognition, get their name in the papers for anything. People don't necessarily read the articles. They just remember, oh, I heard about that guy in the paper. He was doing something. So they vote for him, even if that person or her, even if that person, doesn't line up with their politics. Anyway, so keep your eyes peeled for that. I hope everybody is signed up for CRPA's bulletins, the email bulletins they send out periodically. If you can curate those, pass those on to your lists to help us. We really need to build. The NRA has no money, or they have some money, but most of their money needs to be spent in Washington, D.C., and that's where it should be spent. So all the money that they used to spend in California, almost all of that has been cut, which means CRPA has had to step up and take over where the NRA used to carry the ball. And that's fine, we do that, but we really need help. So I keep, working with them, working for them to try and build them up into, and they're having great results, building into a much bigger presence, because it's all about, we want influence. We want to have influence in Sacramento. We want to have influence locally. We want to make our position be known, and we want to win elections so that we can make others comply with our position, our politics, rather than the other way around. All right, so that's enough of that commercial. I'll turn it over to Matt to talk about regulatory stuff, new laws, also the new gun laws book, CGL 9, the latest edition, which will be coming out for Thanksgiving. And then Josh can tell us about some of the employment and labor law messes that are going on in California.
Thanks, Chuck. So as most of you have probably been aware of, the ATF is currently in the process of making changes to the Code of Federal Regulations regarding the definition of a firearm frame or receiver. I believe there's a comment period that is set to close sometime in September. When the ATF will ultimately have a final rule on that is it's unclear at this point in time. So because they have to consider all the public comments that they receive. And so what I'll do is here, I'll post a link in the chat to show you where you guys can submit comments and send that to your customers if they wish. Generally speaking, for you guys, as far as your businesses are concerned, that's probably not going to have too much of an impact on your day-to-day operations. Where it really will have an impact is if you're selling 80% receivers. That's something that obviously they're trying to go after those. That's what they're targeting here. And on top of which, we have the pending California implementation of the background check requirements for those items, which again, as I mentioned previously in a prior webinar, is something that I think the California Department of Justice is sort of waiting to see what happens at the federal level before they actually take any action with that. But what I really wanted to talk about today, as most of you are probably here for, is the recent bulletin, the important notice, I should say, that the Department of Justice posted through the DES system. So all of you guys should have seen this already. It's titled "Regarding Enhancements to the Dealer Record of Sale DROS Entry System DES, 30-Day Restriction Exemptions and Age Restriction Exemptions." We've been getting a lot of questions on this. And specifically, I wanted to clarify a few things that really, not clarify, but point out the sort of haphazard implementation that DOJ has done here that, surprise, surprise, as far as some of the inconsistencies in what they're saying, and I think where some of the confusion is, and I wanted to help sort of identify these for you. So if you guys are looking at the bulletin, they actually post the actual law as it's currently written. Specifically for the firearm 30-day restriction exemption, Penal Code Section 27535, a person shall not make an application to purchase more than one handgun or semi-automatic centerfire rifle within any 30-day period. That restriction, as worded, is essentially the same as it has been previously, with the exception of the added phrase semi-automatic centerfire rifle that's in bold there. And so if you scroll down to the second page, it then says, please be aware if you sell, supply, deliver, or give possession or control of multiple handguns, semi-automatic centerfire rifles, or a combination of handguns and semi-automatic centerfire rifles within the same 30-day period as set forth in Penal Code Section 27535, you will be in violation of the law. I have a serious problem with how that's worded, because the way the Penal Code is written, it only restricts a person who makes an application to purchase more than one handgun or semi-automatic centerfire rifles. So as applied to you guys are probably aware that when you've been processing DROS transactions in the past, if someone attempted to buy a handgun within a 30-day period, you would get an automatic DES rejection notice, and you would tell the customer, sorry, your transaction was denied. And on the DROS transaction printout, it'll say 30-day restriction or something like that as far as why it was denied. And that's something that has never been a problem in the past, because there's no way for you to know as dealers, unless the person tells you expressly whether or not they've attempted to purchase more than one handgun, or now as the law is written, semi-automatic centerfire rifle within the past 30 days. They could have gone to another dealer and previously bought another gun somewhere else. They might have come into your store on a different day and there was a different salesperson that was helping them, something like that. There's all these issues here. And so what DOJ is doing is they seem to be sort of passing the buck on you guys as far as saying you guys can't do this. And frankly, it's wrong. And the way that they've worded it is in direct conflict with the law, because they even posted the law as it's written in their own bulletin. And so what I think has happened here, if you look at this same important notice, if you scroll down to, I think it's the third or fourth page, talking about the firearm age restriction exemption, it says the Penal Code Section 27510. A person licensed under Section 26700 to 26915, which means licensed dealers such as yourselves, shall not sell, supply, deliver, or give possession or control of a firearm to any person who is under 21 years of age. They are taking that language as applied to the age restriction exemption and trying to apply it broadly to this other restriction having to do with the 30-day purchase restriction, and just applying it across the board and basically trying to scare you guys into not selling, supplying, or delivering any handgun or semi-automatic centerfire rifle within the same 30-day period. So to the extent that you guys get pushback or you guys get cited by DOJ for a violation of Penal Code Section 27535, that's the penal code for the 30-day restriction exemption, please let me know, because this is a serious conflict with how they've actually worded this, and frankly, it's wrong. And it's, I've been doing this for 10 years, and to be frank, I think this is one of the worst examples of an implementation that DOJ has ever done of a new law. So it's something, basically what I'm telling you is this: status quo for the most part. What you guys have been doing in the past, this really doesn't change how you run your business day to day. At least it shouldn't, as far as the law is concerned. However, DOJ is clearly trying to say that it does, when in fact it doesn't. So what I'm going to be doing, and I'll talk with Chuck about this here later, is we're probably going to be putting out an information bulletin on this to help you guys identify this and sort of explain this out in more detail. And so to the extent that you guys still have questions, please let us know. But at the same time, you can then take that information bulletin, and I'd encourage you to talk to your DOJ field representatives on this, because this is wrong as far as how they worded it. And I want to make sure that you all understand this, and also hopefully that the DOJ recognizes the error in its publication and either fixes it, or at the very least doesn't prosecute you guys for it, as this DES bulletin suggests that they might try to do, especially with the recent implementation of the $1,000 fine per violation restriction. So this could be a potential problem if obviously they try to push it. But obviously so far I haven't seen that. Nevertheless, it's still something to be aware of. There's a couple other pending questions through the FFLGuard system, which I'll be responding to here later today. But that said, does anyone have any questions on the recent DROS enhancement bulletin? Do we want to take questions real quick? I just want to make sure before I hand it over to Josh.
Well, the only question I've seen come up so far, can you see that one in there, Matt, in the chat? Does having a CNR and a COE exempt you from the 30-day restriction?
A person who is licensed as a collector to pursue Chapter 44 and has a current certificate of eligibility issued by the Department of Justice, yes, you are exempt from the 30-day restriction as it's written. And that's subdivision B9 of the penal code as written there. So
Yeah, that was the only one that came up in the chat so far.
okay, so I guess I'll hand it over to Josh then.
Well, thank you, Matt.
By the way, just Josh, real quick, we will be sending FFLGuard and CRPA will be sending a letter to DOJ protesting the way that they're interpreting that statute and applying it.
All right, so I'm going to put something up here in the chat for you guys to take a look at. But what I want to talk a little bit about is what the effects of the recent alteration of health orders and the sort of pseudo reopening of the state means for you folks as employers. And it's surprisingly not much different from how it was before the state opened. So as you guys know, while we were operating under the prior health orders, you had an obligation to practice social distancing, to supply masks to your employees and make sure that they use them. There were obviously some indoor capacity restrictions. A lot of that stuff is still in place. Some of it's gone. The indoor capacity restrictions aren't necessarily there anymore. But what you as employers need to know is that there's still a mask obligation. And so let's talk about that. The first thing is, if you have an employee and you know they're vaccinated, you do not have to have them wear a mask. However, if they want to wear a mask and it doesn't interfere with their job, and that would be something in the form of, it potentially is a safety issue for operating equipment, not an aesthetic issue. If they want to wear a mask, you have to let them wear a mask. You have to supply them a mask if they ask for one, whether they're non-vaccinated or they're just vaccinated and are being highly cautious. You have to require masking for certain types of employee transportation, where, let's say, you have a van pool going. You have to require that everyone in the van pool who's unvaccinated wears a mask. You guys still have the same reporting requirements for workplace exposures that you had before they changed the regs. And by the way, I've put these new regs, I put them in the chat box if you want to take a look at them. They're actually surprisingly easy to read through for a set of regs. I was shocked that they're much easier than, for example, the last set of regs on COVID-19 prevention came out. You're still obligated to have your IIPP, your individual injury prevention program, in place for COVID-19. If you have employees who test positive for COVID-19, then you're required, everybody in the exposure group is required to then wear masks. And if they're close contact exposures, you have to quarantine those people the same as the person who tests positive. You still have to offer a form of testing. And when you do have positive COVID tests, you have to offer at least 2 tests to the employees, one at the time of the initial exposure, or I should say knowledge of the initial exposure, and then one time 10 days later. So in any event, there's still quite a bit you have to do as employers in order to make sure that you're protecting your employees to the level that the state deems necessary. The other thing that's still in effect is the presumption and removal of due process for workers' comp COVID claims is still in place. And I don't know if you guys recall this, but they early on in the pandemic, they created a presumption, an evidentiary presumption. The governor actually did it by fiat, but the legislature later came in and backstopped him on it. And that requirement basically says that if you develop COVID-19 as an employee and you're employed at the time, there's a presumption that you had that exposure at work for purposes of collecting workers' comp benefits, with a very difficult set of criteria for the employer to prove that no, the exposure was off-site, and here are the reasons why. As part of that sort of removal, or I should say the assumption of employer liability under workers' comp, there was also a removal of certain appeal rights for employers to challenge a finding that that COVID-19 exposure what was the result of an employment exposure. So, and those are still in place. Those have not been changed. You're still obligated at this point to do your social distancing. So you're still required that where you have to keep 6 feet distance between employees. So there's lots of stuff that you guys still need to do. If you have any questions about it, you should feel free to, ask through the help desk about it. And otherwise, like I said, I've posted the link to the revised regulations that took effect, I believe, on June 17th, which was shortly after we went to our quote unquote June 15th reopening. But beyond that, stay safe and make sure you have all your I's dotted and your T's crossed and your posters up and your plans up and your masking requirements up, and let us know if you guys have any problems. But good luck. Good to see everybody back again.
Signs everywhere, signs.
Yep.
The only thing you see when you go to California. That is it. The quick question came in over on the chat there. Matt, did you see did the DOJ fix the issue of not transmitting DROS with any multiple guns?
I'm not entirely certain what the question is asking. I would suggest maybe having him send a more detailed.
Put it in through the help desk?
Yeah, so I can take a look at it. make sure I'm understanding it correctly.
Yep. Okay. Chuck, you have anything else you want to add, sir?
No, not really. It is good to see everybody back in business. I needed a Ruger 1022 takedown. If anybody knows where I can get a hold of one of those. Other than
Put
that,
it on
no.
our Avis. We can put it on our. We can put it on a list for Chuck. We can bring the Shafulo gun vault back and put it on the list for Chuck and see if any of the clients have it. Actually, I don't know if Scott Duay. We could email Scott directly over at Lipsy's as well. The DES system was rejecting random multiple sales that did not fit the criteria. That's what the Drost question was.
The DES system was rejecting random multiple sales that did not. So I'm going to need to see a specific example and see what the reason for the denial was. And because obviously there shouldn't be just an arbitrary rejection or denial. There could be other reasons that the dealer might not be aware of why it was rejected or why it was denied. For example, the guy had a driver's license that wasn't valid or something like that. The dealer isn't always aware why a sale is rejected or denied. That's the problem here. And so it's going to be the customer that might have to fix something, and it's not the dealer's issue.
Okay.
But to the extent that I can take a look at what you have as far as why it was denied, I'll take a look at it. And
okay. Yep, he said I'll get with the staff and get you some examples. And then we got another question in from Ken. Can PPTs with multiple handguns still be processed?
Yeah, PPTs, as far as I'm concerned, they're still exempt. So the exemptions for PPTs to the 30-day restriction hasn't changed. It's still there. So to the extent that you guys are processing PPTs, that shouldn't be an issue whatsoever. Because again, everyone needs to understand, the only thing that's changed here is the law as written is the exact same law. They've just now added the phrase semi-automatic centerfire rifle in addition to handguns. So the law is more broad in its application now, but the actual law itself and the exemptions are still the same. So it's still, like I said earlier, for the most part, as far as day-to-day operations for you guys, it's still status quo for the most part. So.
All right. All right. I think that wraps it up over here in the chat. And we appreciate everybody joining us today. Our next call is going to be on Monday, August 2nd. Monday, August 2nd, same bat time, same bat channel. Hold on. One more question. Does that mean one handgun or one rifle per month? Right. This is what we talked about at the beginning. Yep.
Yeah. So the way the law is written, DOJ is interpreting it that if a person buys a handgun on July 1st, they can't then also buy a semi-automatic centerfire rifle the next day. So it's either or. You can't buy both of those items or one of each within the same 30-day period is how it's going to work. But again, here's the important part, as I mentioned, for dealers, it doesn't really change how you run your day-to-day operations as far as when you process Drost transactions. Unless you somehow know that the guy recently purchased a handgun or semi-automatic centerfire rifle within the past 30 days, you shouldn't necessarily be too concerned with if they're going to get rejected or not, because you don't have that knowledge beforehand when you submit the Drost. And so that's like I said, it shouldn't change as far as how you process transactions on a regular basis. Although I see Thos has another question. Recently, I received a letter from Cal DOJ mailed to my home. Important notice regarding the purchase and resale of non-roster handguns. Were they sent to everyone? So I think what you're talking about there, as far as the important notice regarding the resale of non-roster handguns, that's DOJ's implementation of Assembly Bill 2699, which is the changes recently to the handgun roster as applied to certain exempt individuals. They've made changes to that as far as who's exempt from the handgun roster, but also what DOJ is required to do now as part of those changes is sort of maintain a list of who buys handguns pursuant to an off-roster exemption, and then mail them a notice of the limitations on the subsequent sale of those off-roster handguns, which they technically cannot do. As it stands, if a law enforcement officer buys a handgun that's not on California's roster, technically speaking, they should not be able to then resell it to a subsequent third party who is themselves not also exempt for some other reason. But there's problems with that as well. But just basically what you receive there is just a generalized notice that everyone is getting, because DOJ is mailing these notices out pursuant to the requirements that they're required to do so as far as tracking these off-roster sales. So yeah, something that is not specifically targeting you. It's something that they're sending it out to everyone. Since this sent out quite a while ago, I was surprised to receive one. Okay. How are we supposed to know if they are group 1 or group 2? Have they prosecuted any dealers for violation of this? I'm assuming what you're asking there is whether or not they are general law enforcement or if they're one of the expressly listed law enforcement exempt entities. Again, this is one of those problems that AB 2699 has. I will respond to that because that's a little bit more of a nuanced answer to that question. So I will send out a generalized response on AB 2699 again. But as far as AB 2699 is concerned, the general answer I can give you, if you guys refer to that information bulletin regarding exempt law enforcement officer transactions that should be available through FFLGuard's website, on, I think it's page 12 through 15, talks about the AB 2699 and the handgun roster generally and how it applies to dealers. So as far as generally speaking, what you need to worry about is what's already in that bulletin. And so we'll make sure to send that out and make sure you guys have that information as far as how to process these transfers and what to be concerned about for subsequent sales and things like that. So.
All right. Well, thank you for your time. Enjoy your day out there in California, everyone, as I know you're just getting started and the rest of us are gearing up to go to lunch. So Monday, August 2nd, we will see you all again. And please, everyone, hope you all had a great 4th of July, and please stay safe and follow those rules and regulations. We will see you all again next month.